morning, everyone. Thank you for joining us this morning. Welcome to everyone in the room and to those who have joined virtually. This is Breakaway Room 3, where we are dealing with the good, the bad, and the profitable, and all things franchising. For those of you who don't know, I am Siobhan Newton-Molen. I am an associate in the dispute resolution team. I am joined by a wonderful group of panelists today, and I will introduce you to them shortly. But beforehand, I just have a couple of house rules to go through. First of all, there will be a Q&A session after the discussion. So if you have any questions, you can just raise your hand, and there is a floating mic that will come around. And then you can ask your question. And then for people who have joined virtually and have questions, you can leave your questions in the comment section, and we will deal with them afterwards as well. And then there is lunch after this, so please stick around, chat to us, take some photos of our celebrities to the left of me. And at the end of this, there is also a survey, so we'd be grateful to have your feedback, what worked for you, what didn't, how the facilities were, how wonderful our speakers were. And then, if you're making use of social media, please use the hashtag Crammer 2024 hashtag. And then, last but not least, there is complimentary Wi-Fi on the top right-hand side of the agenda, if you don't already know. Okay, so welcome to the wonderful panelists. First of all, we have Thando Manetsa. He is a partner specializing in commercial litigation in our dispute resolution team. He specializes in contractual disputes, unlawful competition matters, and corporate commercial disputes. He studied at Wits University and was admitted as an attorney as far back as 2012. I was in grade 11, just for context. Then we have Eugene Honey. He is a partner specializing in trademarks and copyright matters, and also specializes in commercial IP matters, such as franchising and licensing, so perfect person to have on our panel today. He's also a legal advisor to the Franchise Association of South Africa and has been since 2002. And I was not born when Eugene was admitted in 1991. I was very far out of the picture at that point. And Eugene completed his studies at Rhodes University. Then we have Mercia Finn, partner in our commercial team. She focuses on commercialization of intellectual property with a particular interest in data privacy, electronic communications and transactions, consumer law. Quite a mouthful, but I think I got it. And once again, a Wits student, and it was admitted in 2010. Yes. And then we have a very special guest, Mr. Fred Machato. Thank you for joining us today. This is the CEO of FASA, the Franchise Association of South Africa. Fred also practiced as an attorney for 8 years beforehand, and then went on to become the head of legal and regulatory affairs at the Advertising Standards Authority of South Africa for 9 years. And also, interestingly, participated in drafting the Consumer Protection Act. So for those of you who are wondering, I did in fact stalk Fred's LinkedIn profile yesterday. So we're very excited to have you here, and thank you so much. Just to kick off this discussion, interestingly, I think we all know, the importance of franchising in this country, and I think in the last 6 decades, franchising has played an incredible role in not only our economy, but also contributes 15% towards our GDP. In South Africa, we host about 68,000 franchises that spans across 14 sectors and offers about 500,000 jobs. So without further ado, Thando, I'm going to hand it over to you. The first question is, and you can sort of take us through things generally, but what is franchising, and what are the sort of goals that franchisees and franchisors aim to achieve when entering into franchise agreements or franchising structures?
Yeah, no, Siobhan, thank you very much. Thank you very much for the very kind introduction. So I think the starting place is to look at franchising from the perspective of what it is from a legal and commercial perspective. I think there are common definitions, and I won't suggest a all-encompassing definition in this, but I want to start off from how I would understand it from a commercial and legal perspective. So I think you can understand franchising as a sophisticated form of a license in terms of which a franchisor grants to a franchisee a license to use a bundle of intellectual property rights, usually at least trademarks, copyrights, and know-how, and a full business concept with the use being subject to certain terms and conditions. So I think what you can take from that is obviously what you're effectively giving a franchisee, if you're a franchisor, is a license. That license encompasses conferring your intellectual or assigning your intellectual property rights, and the development of a business system, and that can take various forms depending on what franchise you're dealing with. But I think it's also quite useful to look at it from the perspective of what are the objectives or goals that a franchisee and a franchisor actually wants to achieve. So if you look at it from the perspective of a franchisee, I think it ties in quite nicely with what you said earlier on with franchising in general being constituting 15% of South Africa's GDP. I think a franchisee, usually it's somebody that's not experienced, doesn't have any prior experience in that particular area of franchising, and looks to enter into the market and into the industry through a vehicle that has already been created by a franchisor. So it's quite an easier way to get into the market, a relatively less barriers of entry than what you would associate from other businesses, let's say, for instance, starting a business from scratch. So I've worked with clients, for instance, that want to take part in a franchise, have no prior experience. They have an interest in a particular business, but and I think the only barrier they have is then to try and raise the capital to purchase the franchise. So it's from that perspective that franchisee then is also able to then create jobs once they've established a franchise. So I think that from the perspective of a franchisee, it's a very good business. It's a very useful way to look at it as an entrepreneurial tool. If you're an entrepreneur that doesn't necessarily have an idea to start something scratch yourself, you can then enter into a franchise. And I think from the franchisor's perspective, I look at it as scale, principally. You have a franchisor that might not necessarily have access to certain markets, maybe not access to certain geographical areas, and would like to scale their business, and then has developed this business system, has developed this bundle of intellectual property rights that they effectively package to a franchisee. And what you'll find with the most successful franchises is that they're spread out across the world, across South Africa, into areas that might ordinarily be difficult to enter if you are the franchisor in that instance. So it gives you an opportunity to scale quite quickly, but you have a trade-off there, obviously. The obvious trade-off is that obviously if you set up your own business in an area with your own infrastructure and all of that, the profits are going to be your own profits. You don't necessarily have to share those profits. But if you have a franchise model, you have the opportunity to get to a lot of places, have a lot of reach, maybe reach certain people that you might not ordinarily have been able to reach. But the trade-off is that you have to charge a royalty fee. So you don't get all the profits, but you only derive your income from a royalty fee.
Okay, thank you very much. And what do you think is the importance of franchising within the context of a broader South African economy, or the broader South African economy at least? Yeah, look,
I think this discussion is going to encompass a lot of the some of the positives that we talk when you talk about what we can do in Africa, how we can expand our global reach, and how do we reach other different continents. Some, if you look at some of the big franchisors in South Africa, McDonald's and KFC, these are entities that started in the North America. They've broadened their horizons to multiple places. And like I said earlier on, they've been able to scale their businesses globally. So I think from a South African perspective, that is for me the key issue. I think what you have is an opportunity where businesses can reach different places, reach different markets, and reach different people. And I think that is also quite important when you understand it from our transformational objectives as a country. You'll have businesses that that include a wide variety of different people from different age groups, from different demographics, and that's obviously going to be positive for the economy ultimately. Ultimately, our economy will only grow when it becomes more inclusive. And I think that franchising for me is an obvious, it's an obvious tool to reach those type of goals. So I think I understand also there has been discussions by government in terms of its importance to the country. Like you said, it's 15% of our South Africa's GDP. That's significant. That cannot be ignored. And from all indications that I've seen, there's positivity in the market. I think Mr. Makhato can probably speak to that better than I can. In fact, one of the surveys that FASA did prepare, which I just want to read some of the outcomes, which I thought were quite insightful into what the potential is for franchising in South Africa in particular. So what they say is franchisors continue to be optimistic about business growth, which continues to strengthen, and the expectation that turnover will grow in the next financial year is almost unanimous, which is quite a rare feat to reach in anything. The positive attitude expressed by franchisors is echoed by franchisees, with 88% believing that the turnover in their business will grow in the following year. The franchisees that were especially optimistic about future growth could be found in the following categories: automotive products and services, building office and home services, business-to-business services, childcare, education and training, and real estate. The one area that has been struggling is franchises in in-dine restaurants and fast foods setups were less optimistic, believing that turnover would not change the next financial year to a great extent than franchises in other categories. And then taking the size of the franchise into account, it was noted that small franchisees would like more support in marketing their businesses, while very large franchises requested additional support with on-job training, which is understandable. So I think in general it's an optimistic area. I think that government has recognized its potential. I think there's need for legislative intervention, which is to deal with some of the issues that we'll deal with later on in our discussion. But in general, I think it's probably the one area that has got, I guess you can look at it as a low-hanging fruit from a growth perspective in South Africa.
Thank you. Some very interesting points being made there. But I think you knew this question was coming as the only litigator in the group.
Yeah.
There have obviously been quite a few high-profile cases that have been reported on and that have been in our high courts recently. Could you kind of, go through some of those cases? I know some of them have ended up at the SCA and some of them are still pending, but particularly the one we're dealing with. But if you could just take us through some of the key legal principles and the issues that were sort of identified or that you've at least picked up within the franchising system, and from what the court's perspective on those issues were and what the feedback was in general.
Yeah, no, thank you, Siobhan. I think, look, disputes are going to happen, ultimately. I think if we didn't have disputes, you and I would not have a job, which obviously, we're biased in that sense. But I think on a serious note, I think when you see an area become more dynamic and grow, what you tend to find is that it grows because the commercial activity there becomes complex, and when there's greater complexity, there's probably usually greater opportunities for disputes. And I think that is kind of what we found in a lot of the franchise disputes that we've been involved in, and some of the ones that I'll comment on in a moment. So I think disputes are to be expected as the industry grows. I think also this industry has been affected a lot by COVID. There's most of our industries are kind of coming out of it, but like I said earlier on with the in-dining franchises, those are still taking a hit, and they're not necessarily foreseeing greater growth in the future. And I think you can see that. You'll probably find that if you look at the case laws, there's probably a lot of disputes in that area, or specifically in that sector of franchising. And I think overall, what is important to understand with the structure of a franchise is that you have a franchisor, and as I said earlier on, in scaling your business, the franchisee then creates a franchisee network. Those franchisee networks are a lot of the times very ordinary people. Some of them might not necessarily have a business degree. They've found an opportunity, they found some capital to purchase the franchise, and then they take part in that business. And these are ordinary people, and these networks then become very tight-knit. And when there's changes in the franchisor's model, often those disputes may start in a very small sector. Maybe, let's say, it starts in Johannesburg, and then within 6 months, they spread to Cape Town. And you have a very volatile franchisee network. And I think the large cases that have made it into the news, and in particular, I want to focus on Cash Crusaders today. But those have kind of come from the fact that there's a general revolt, if I want to call it that. I don't want to use too much of a strong word, but you have a group of franchisees that have effectively banded together, and they believe that their combined power and their combined efforts are able to then counteract, if you want to call it that, the powers of the franchisor. So I think that before I go into the cases, the one message that I've seen is the success of the franchise really dependent upon how your relationship works between your franchisor and your franchisee. There's some cases that have spoken about the concept of Ubuntu within our commercial interactions. And you can look at that concept of Ubuntu in the more commonly understood way in South Africa, but I think for me it's really just a level of certain respect that one has to have between franchisor and franchisee that understands that you kind of both need each other. And I think once you had COVID and lots of issues then came from that relationship broke down, which kind of led to a lot of the disputes that we've seen. So I think that the first part I want to focus on is actually the disputes that Pick n Pay has been having with its franchises. And I think this illustrates this point quite well. Pick n Pay is obviously, if you read in the news, they're not doing very well. And I think there's a major cash crunch, if I can call it that, based on what I'm seeing from the case law. So what they've effectively done, is embark on a campaign or a legal strategy to recover as much as possible from its franchisees. I just, for my own searches, I found, I think, about 4 or 5 cases from Kimberley to Cape Town and 3 in Johannesburg that deal with how Pick n Pay is trying to go about recovering the rear royalties that are due to them. And just to make it, just to take a step back, I think that the 2 primary disputes I see relate to royalties. So, like I said, you as a franchisee purchase a franchise, and as a consequence of you having the right to use that intellectual property in business, you have to pay a royalty fee to the franchisor as the franchisee, and that's a very common dispute in the space. It's a common dispute in any space usually, and so how Pick n Pay went about trying to secure its position is that it had its franchise agreements in place, and it secured the performance of the franchisee by way of a notarial mortgage bond. So what that means is effectively is that you have security. You as a franchisee have to put certain movables assets as security for the performance of your obligation in terms of the franchise agreement. So Pick n Pay have these various notarial mortgage bonds. It's a business that is geared for that a lot better than maybe other businesses, because you have lots of infrastructure. It's a fast-moving product, and so it's more easily suitable for that. The alternative could usually be to secure that stock and the premises through the agreement itself, the franchise agreement itself. So you have contractual provisions in there that deal with what happens for you to recover what you need to recover. So Pick n Pay then have executed these notarial mortgage bonds throughout the country. The notarial mortgage bond itself, when you execute it, is an inherently urgent matter. So they were able to execute them through urgent applications. And what it is just to secure your assets before somebody else then sells it. So the one case that was quite interesting for me was Pick n Pay and AGP Group. It's a recent court case that has been decided the Johannesburg High Court. And once again, what happened in that case was Pick n Pay trying to execute its notarial mortgage bond. And what the courts, the franchisee in that instance, tried to raise two arguments that are commonly seen in the space. The first one was that there was an issue with Pick n Pay's business system. So Pick n Pay introduced the discounting system, which I understand is basically discounting to consumers. The franchisees accused them of, argued that discounting system resulted in a loss of their revenues. And that change in system then contributed to them being in arrears with their royalty. And then the second one, which is quite common, is they said that Pick n Pay's attempts to execute the notarial mortgage bond were unjust and unconscionable. And that's just a fancy way of saying that it's basically against public policy, where the court rejected both those arguments. So why I wanted to focus on that is that it kind of leads its way to the other side of it, which is the second major area of dispute that I see, is the enforcement of restraints. You have a franchisee that wants to take the lessons learned from the franchisor and then use them in another context, in the business of their own, which we as lawyers commonly refer to as springboarding. And in the Cash Crusaders case, what effectively happened there was, again, a business change happened within Cash Crusader. I won't go into the details of that. It really is related to the National Credit Act and a change in the act which resulted in a change in Cash Crusader's business. And they tried to implement this change, and the franchisees were not happy with it, and en masse, a very large section of Cash Crusaders franchisees wanted to defranchise and cancel their franchise agreements. And various disputes then arose from that issue. And principally, what it really related to is what are the franchisor's rights in taking control of their business once a franchisee wants to leave. And we commonly refer to that as what are the post-cancellation rights that a franchisor has once a business is over. But yeah, I think there was a lot of, that case is still going to the ACA, a bit of backwards and forth on that, but those are the two common disputes that we kind of see in this area.
Okay, thank you, Tando. Just on that, with the term of a franchise agreement and on the post-termination solutions and rights for franchisors, I think, and we'll just sort of go down the line now, Eugene, this next question is directed towards you. But, we understand that there are two overarching sort of important aspects for franchisors, and that's managing IP and then also the rights that flow from the franchising agreement. Can you just elaborate slightly on what it means to manage those IP rights and what it is exactly that you're managing, franchisors are managing? Sorry.
Okay, thank you. Thanks very much. Hello, everybody. Yeah, Siobhan's quite correct. In a franchise, there are two overarching, let's call it protection mechanisms or avenues to look after in protecting your rights during the term and your income stream during and also afterwards. So firstly is your IP, second contractually. So we'll do the franchise agreement in a moment and related agreements, but firstly on the IP side. As I was saying earlier today, it is much easier to enforce IP rights very often than, for example, a contractual restraint. So you almost need to, right from the beginning, right from the very start of a franchise, you want to protect your IP. And as Tando said, the cores are normally trademarks, copyright, know-how. And I've used know-how there very broadly, trade secrets, confidential information, etc. So as I was saying also earlier today, it's much easier to enforce your rights in an IP franchise, IP-rich franchised business. Because you always want to, at the end, post-termination, have your IP rights, and sometimes we litigate just on the IP rights, and sometimes we litigate obviously on both, but contractually and IP. But sometimes just in the litigation, people are still using the IP, so you might just use trademark infringement and copyright infringement. Quicker, easier, insofar as the courts are quicker from time to time. So why is it important? The IP is what you are licensing. The IP in the business system is what you're giving to your franchisees. It is what they're using. It is what they're paying for. It is the value in the whole business. So if we start dividing them up, let's look at your trademark first. Trademark is the core, it's the cornerstone in the whole franchise system, the brand. Right? What you need to protect there. Obviously, your word trademarks, your logo trademarks, and then any others as well. Particularly if they become important over time, slogans, unique distinctive trademarks in the trademark system. So next, what is important is copyright. Copyright is an area that's critically important, often not so well managed by franchisors. So let me tell you first what copyright is. It would be your ops manual, it would be your website, your menus, even to the extent that any of your know-how is written down, your methodologies, your systems, your processes, etc. If it's written down, it's also protected by copyright. So copyright, much of the franchise system is written down to some extent. So a pitfall with copyright, and something that some franchisors don't always remember, is that the general rule is the author is the owner of the person who created the work. So now you go out and outsource your website, you go and outsource your logo, you go and outsource your ad, you go and outsource an app. The whole franchise system maybe has been outsourced. You might not be the owner. So if you outsource creation, development of copyright, you need to make sure you've taken ownership, because whatever you're giving to your franchisees to use, you need to own. And you need to own, you need to manage, you need a master list at all times of your copyright, because lots of this could be in the ops manual, some of it in the agreement, but you should have your own master list so that you know what you're managing, you know what you're looking after, you know what they're using. When the time comes for them to stop using, you've got your list, you take it all back. Similarly, also, know-how has the same pitfall. You outsource know-how, you outsource your recipes, you outsource methodologies, you bring in expert consultants, etc. You need to take ownership of that, because you might not own your own know-how. Now you want to enforce your know-how, you find, oh, my word, I didn't write that little piece, and therefore I first have to take assignment, so I own what I'm licensing to my franchisees. So know-how, as I said, would be expertise, it would be processes, experience, methodologies, systems, formula, whatever. So, yes, step one, IP, and ongoing, because as these businesses develop, they grow, IP develops, changes. The IP should be managed on an ongoing basis as part of the objectives, strategies, etc. of the franchise, and whatever IP is used in these franchise businesses should be reviewed and protected all the time. I think I lost track of my question.
No, but on that, then what would you say is the role of a franchising agreement, specifically how that should be managed, excuse me, in conjunction with, for example, an ops manual?
Okay, so firstly, the agreement, people often, especially franchisees, would say it's so onerous, it's one-sided, etc., etc. But the franchise agreement is actually there to protect the whole franchise system. It protects the franchisor, and it protects the franchisee as well, because the franchisee is investing in the brand, and it's in the best interest of each franchisee and the protection of their investment that the franchisor has the rights to keep everybody in line. And if you have one bad apple in a franchise system, it affects the businesses of everybody. I remember a couple of years ago on Carte Blanche, there was a fish and chips franchise. They had a complaint of old oil at one of these fish and chip shops. What happened was there were immediate declines in turnover of about 20% in all of them. So the franchisees often have a small picture viewpoint, not the big picture, and it's almost like an ongoing education to franchisees about what is in the franchise agreement. So yes, the franchise agreement, like the IP, must be developed not every year, but must be looked at as the business grows. It must be reviewed. It must address difficulties. It must deal with key drivers in the system. And Siobhan, as you correctly pointed out, some of those things should be in the ops manual. You don't want to overly clutter the agreement. And the beauty of the ops manual is that it's a dynamic document. This is updated. It's reviewed as the products change. As your menu changes, you put it in the ops manual. That's the new menu. You introduce a new software system. You introduce a new app. You introduce a new service. You go into new areas where there's a different, let's call it, let's say in a restaurant, they have a different culture there, and they need different food. So you have then almost a sub-ops manual for food in that region. I've noticed traveling, you see McDonald's will have different menus all over the world. So that's the beauty of the franchise agreement. And I think something that is neglected by some franchisors is they do not properly manage, properly keep up to date, and keep on refining the ops manual, because this is the business system the franchisees are using. And to the extent that the business model is, as I was saying earlier, IP rich, it's easier actually also to enforce your rights later. So the agreement, like the IP, must be reviewed continually. Yes, every few years, okay, what have my issues been? What have the difficulties been? How has the business changed? How has the business developed? And also, obviously, as you expand, and Mercy will talk about that, one needs to look at perhaps variations thereof, obviously accommodating laws in different countries. I might have lost my question again.
No. Just going to post-termination now, what should franchisors consider and include in their post-termination plans and processes, in your opinion, obviously?
Yeah, so the post-termination flows precisely on what you've managed all along. Is all your IP in place? Is your contract up to date, organized, and addresses all the issues and deals with the matters? So post-termination, again, you've got contractual rights and you've got IP rights. So I would suggest to franchisors, because termination happens from time to time, disputes happen from time to time, and all franchise agreements lapse. And there's a risk at every lapsing, let's say they're 5 years or 7 years, that issues might arise. So franchisors should have let's call it a lapsing termination plan, and everything that I've covered in the IP and everything that you would reasonably require in the franchise agreement must be there. And in the post-termination provisions, you need to obviously have provisions. You can't use my IP anymore. Then there should be things like if there are licenses into the franchise systems, apps, platforms, websites, the franchisor has an overarching right. Ideally, the franchisor is the owner of the IP in the system, but sometimes software is licensed in and then sub-licensed, or it's licensed directly from providers. So the franchisor should sit with the control, because all its IP is sitting on those systems. It must be able to also stop immediately. Sometimes you want to litigate against ex-franchisee and you can't, because they're entitled to use the system because it's an independent service provider. So you need to make sure that every single part of the business system of the franchisee, from an IP perspective, licensing, etc., from a contractual perspective, all protected. So that would include stop using my IP. Okay, premises. Have I got the rights to the premises? If the franchisor didn't take a head lease or owns the premises, then there should be obviously a sublease to the franchisee, but the franchisor should have an entrenched right to take over the premises if it wishes. Now, that can be in various ways. The franchisor must approve that premises, approve the lease, have the rights in the lease, have the rights in the franchise agreement. Next point, assets in the business. There's really two scenarios about the assets in the business. The first scenario is you want to buy, the franchise business is now maybe leaving, you would want to have rights to acquire that business at a reasonable commercial terms. Now, on termination, immediately there's been termination, the franchisee has lost all the goodwill. The goodwill comes from the use of the IP, the business system. So now you don't want to pay him for your own IP. So then you should have a right to acquire all the assets in the business immediately, automatically, at your option. You should have an evaluator on hand. He walks in, evaluates the thing. There's a process. Once the evaluator report is done, the franchisor exercises his rights, buys all the assets. I'm leaving something out, I think. But anyway, it's IP contractual, also like Pick and Pay had to. Yes, there would be guarantees, there could be notarial bonds, whatever contractual rights are appropriate to protect yourself in the business, one should have in place. So in the past, for example, there were sureties, now there are more guarantees. One of the reasons for that is often if the debt is extinguished, the surety might no longer be liable, whereas that's not the case with a guarantee. So I think it's just the short answer is be super organized during and be ready with your plan at the end.
Good answer. So I just think in the interest of time, I'm going to move over to Mersha, but before doing so, Eugene, is there anything else that you want to conclude on or anything else that you want to say before handing over to Mersha?
I think you've got the highlight.
Okay, sorry, Mercia. Just a quick one for franchisors wishing or trying to sort of expand into new markets or to even expand into Africa. What would your advice be to those franchisors, specifically in relation to their IP and managing their IP?
Okay, so can you hear me?
Is it on?
Okay, so firstly, it's the protection of intellectual property. So as Eugene spoke about, your registering of intellectual property rights. Intellectual property is territorial. So if you're going into a new market, you want to actually register your trademarks in that market, you want to register patents if that is applicable to that franchise system, and ensure that you can actually protect it in those new markets. That also ensures then that the goodwill that is associated with that intellectual property then flows back to that franchise. So there are numerous reasons why it's very important to ensure that you register and protect your intellectual property in your various African markets. Another one of them is for valuation of your business. So one of the greatest aspects of the value of a franchise is its intellectual property, as Eugene discussed. So you want to ensure such that that value is actually flowing back to the franchise, that you've actually then registered that intellectual property in the jurisdictions that you want to operate in. And then that also provides some business stability for your franchisees in those areas because, they have these rights to fall back on and rely on. Another reason why it's important to register and protect your intellectual property in these markets is that for the purposes of legal enforcement. So, if there's any infringement in those markets, you want to be able to have a very strong right. And registered IP rights, as Eugene mentioned, are very strong rights and very easy to enforce. So you want to ensure that those are also registered for that purpose. And then, of course, there is the franchise agreement and compliance therewith. So there will always be some sort of framework that is set out in your franchise agreement and your operations manual as to how franchisees have to operate and use that intellectual property. And so registration of that IP in those markets also just enhances that compliance. It helps with regards to exactly the rights that they will have in those territories, how they can use that intellectual property there. And then also, of course, you your intellectual property is there to differentiate your products or your business from similar businesses. So market differentiation is very important as well. And is another reason why you want to ensure that you register whatever is registrable in those territories. And then also just the prevention of misuse of your intellectual property. So that could be misuse by third parties, but also with your franchisees. So this then again just enhances your rights to enforce the very specific requirements for dealing with intellectual property in those territories, and ensures that it's quite certain what can and cannot be done with that intellectual property. So IP protection being the one issue that you need to be concerned with, but also then exchange control. So with regards to intellectual property, it is considered capital in South Africa. So any exports of capital to another country has to actually be approved by the South African Reserve Bank. And so any export would include licensing of that intellectual property, but also assignment, or transfer of that intellectual property. So you have to ensure that then you are adhering to those requirements and actually making an application to the Reserve Bank or an authorized dealer, as the case may be, that you can use that intellectual property in those various other markets.
Thank you. And then, are there any other factors from a legal perspective that should be taken into account or consideration?
Yeah, so I'll mention two factors. One is actually reviewing your franchise agreements for local legal compliance as well as enforceability. So obviously different territories have their own laws that are applicable to them. And so you want to ensure that your agreements, even if they're subject to, say, laws of South Africa, will actually be enforceable there. So first of all, you've got to look at what the local laws are that have an impact on that franchise agreement. There may be consumer laws that impact that. There may be some tax laws that have an impact on that, etc. Even employment laws that have an impact. So we want to ensure that we're complying with those. But also, you want to ensure that it's enforceable in the event that you may have a franchisee that does not adhere to the terms and conditions of the franchise agreement. So when you want to go in and request recourse from local courts, you need to ensure then you can enforce it because it is compliant with the local laws in that particular country. And then you also want to mitigate your risks, essentially. So a local law review is important because they would look at things like tax issues, environmental issues, etc., that may be applicable to the particular business you're running. And then, look at exchange control as well, look at any employment-related obligations that you might have, and ensure that you've mitigated any risks of violating those. And we have examples where, unfortunately, there have been violations of this when parties have gone into other African countries, and they've had to pay quite dearly for it. That's very important. And then, of course, again, the protection of your intellectual property. So ensuring that any of the terms in your franchise agreements and disclosure documents also then speak to intellectual property protections in those jurisdictions as well. And then things like cultural and legal norms. So that's very important in Africa. There's various different cultural and legal practices that apply in your various jurisdictions. And so it's important that you actually have consideration for those. And certain norms in different jurisdictions are very different in other jurisdictions, So certain issues that might be enforceable in South Africa or very much speak to our cultures don't speak to the same in other African countries. And then you also need to avoid, obviously, void or unfair clauses. So in some jurisdictions, for example, penalty clauses are absolutely perfectly enforceable and fine, whereas they would actually be void and unenforceable in other jurisdictions. So again, that's another reason why you want to ensure that you have that local law and compliance review of your agreements to ensure that you're not falling foul of any of those, or you're not containing any provisions that you may want to rely on but you actually can't in those jurisdictions. And then just lastly, public policy. So that's very important. Again, it's something that applies differently in different territories. So there may be certain employment issues that would violate public policy in various African countries. There may be certain tax issues, environmental issues, consumer protection issues that are required. So you certainly have to ensure that you look at public policy as well, and ensure that your agreement doesn't fall foul of that, because if an agreement is in violation of public policy, then it's generally seen to be unlawful. So a very, very important consideration there. And then the second issue is regulatory compliance. So obviously, as we've said, the regulatory requirements in various jurisdictions differ. So, businesses sometimes need licenses to operate in various territories. There may be a need for registration, certifications, approvals in those various territories. And so it's very important that you actually have that regulatory compliance in place so that you are sure that you can operate in those territories. And I think of the example of MTN's expansion into Nigeria, which I think illustrates a lot of these points, where, one, they have attracted a fine from the regulator there for not disconnecting certain numbers, where the regulator wanted to shut down kind of illegal use of SIM cards, because they may have been involved in sort of nefarious activities or terrorism, etc. So, they actually wanted those to be shut down. MTN did not do so in time. Initially, the fine, I believe, was $5.2 billion, but that was reduced to $1.6 billion. So that's quite hefty, and that could, I think, have easily been avoided. But also, there was a tax liability that was incurred by MTN in the same territory, Nigeria, and that was probably around $53 million. And that's just, again, for not complying with regulations with regards to tax and exchange rates. So very, very important that you actually have, adhered to that. But I think to end on a more positive note, because I think it's been overly negative, there are definitely examples of very positive expansions into Africa. I mean, ShopRite is an example that I think has gone very well. They have had their challenges, and they have had to shut down a few locations. But I think the key issue with ShopRite is that they actually thought their strategy through very well, and they actually went back to the drawing board when they saw certain things weren't working, and they sort of scaled their operations, kind of simplified operations, because I think in certain African territories, you do need a more kind of simplified approach, and you've got to look at the economic differences between their consumers and ours, and I think ShopRite did very well to do that, and they've managed to actually yield a profit, in those various African territories.
Amazing. Thank you so much. Fred, are you still with us? We haven't forgotten about you. We saved the best for last. Well, based on what's been said this morning and off the back of what both, Thando, Eugene, and Mercia have mentioned, do you maybe want to speak to FASA's role and why franchising is important, specifically within a South African context?
Thank you for inviting us. We are happy to be here. I think my first activity with Crammer was to come and listen to speakers. But then I was called upon to come and talk. So we appreciate the platform because I think it is important for us. I think let me start by saying what is not the role of FASA. Because there is a belief that FASA is supposed to do things that we are not doing and we will not do. One is that we don't get franchisees for franchisors. That's not our role. But the expectation is that when businesses join FASA, they join FASA because they want FASA to grow their network. We don't. Our role is to create a platform for franchisors to meet up with the franchisees and other suppliers. The suppliers, they expect us to create the market for them, to introduce them to franchisors and franchisees. That's not our role. Our role is to create the platform. Our role, we'll have to look at the mandate. What is the mandate of FASA? Because I think that's the most important aspect. The majority of members and entities don't look at the role and the mandate of FASA. They look at what they expect from FASA. Our mandate speaks of three things. One is to promote ethical franchising. So I think if we had more time, we'll unbundle what is that. So secondly is to protect the industry. Thirdly is to lobby government and other stakeholders. Lobbying seems to be focused more on government. It's not only about government. It's about other role players within the sector, the ecosystem. Why do we promote ethical franchising? I think the reason why FASA was formed, it was in consequence of the activities that were happening then. I think I don't have to tell you that it was formed in 1979, because you know that already. That is in the public domain. There were activities that showed signs of misbehavior, where you have, I wouldn't call entrepreneurs, but they are entrepreneurs in their own space, because if you do what you do to make money, yeah, then that's the skill that you have. You have identified the gap in the market, and then you want to use that. As to how you do it, whether is it good or bad, at the end of the day, you are able to make a living. But then, I think the franchisors had to cap that, where you have individuals who are taking advantage of the potential investors in franchising, where you have the scammers. So I think then the honorable franchisors had to come up with a mechanism of how do we protect our businesses, how do we protect the industry, then they form the association. So hence, you have to promote ethical franchising. A simple example, from 1979 to yesterday, I received a call from one guy in Northwest asking me, do you know this brand? Can I invest in it? And I said, they are not a member. My friendly advice, don't invest in it, because we don't know them, we don't know what they are doing. So, because there are those who start the business not to run their business, but to sell franchise opportunities, knowing very well that their systems eventually will crash. So they will open a store. For 3 months, they close you down, they sell it to somebody. 3 months down, they close them down, they sell it to somebody. So we are saying become a FASA member, because we have a code of conduct that says the standards for franchisors, how to operate their businesses. It's a voluntary association. Why is that important? Because as an entrepreneur, it has to be in your wiring that you want to do your business honestly. You don't have to be forced by law. You know you want to grow your business, and you have a strategy of how to grow your business. Then why do we protect the industry? We have those guys that sell their concepts in the coffee shops, right? Then you see it on the internet. It's very interesting. You meet up with them at the mall. Then you don't know where they are. They showed you the profile. Is interesting. They show you the numbers that you cannot prove. I think everybody here is talking about the disclosure documents, the franchise agreement, and so forth and so forth. Then you pay upfront before you can even see those legal documents. 2 months down the line, you cannot get hold of the guys. Then what happens? Your money went down the drain. Why do we lobby? We have come to a conclusion that we need to open up the environment. We need to open up the space. Franchising can do more. Benchmarking with other international markets, we only contribute 15%. But other markets, they contribute up to 40 to 60%. So we can do so much. Then we need to bring government and other stakeholders on board to say, let's use franchising as a business model that we could use to grow our economy, to create jobs, to create more investment opportunities. How do you do that? Is to engage with the Department of Small Business and Development as well as the DITC. But we also want to include the Department of Basic Education, because I think entrepreneurship has to start at the young level. Then we are also attracting international associations and businesses to come and invest in the country. So there's so much that we are focusing on. That's our mandate, that's our role. So that is why you'll see us in each and every forum, bringing awareness and information to aspirant franchisors and franchisees and students and young people.
No, thank you. And you mentioned, the lobbying and that sort of thing. Can you just elaborate then from a future perspective and maybe more growth and contribution towards the GDP? What are FASA's goals and ambitions, and how do you go about growing that percentage from 15 to 30 to 35 and so on and so on?
Thando spoke about entrepreneurs who go into franchising without knowledge, without understanding. Some, they've access to funds. Maybe parents have left some funds in the trust funds that you can use. Some, they just have the passion of being entrepreneurial stuff. So we are putting in place building blocks. One, we have now formalized franchise education. We have launched franchise manager occupational training on the 14th of September. So you can go to QCTO, is accredited by SASAQA, is now offered by educational institutions. It's a formal course that you can do to get into franchising. The second step is to make sure that government adopts franchising as a business model for economic recovery. That speaks to this course. So what we want to do is to say, if you want to go into franchising, you have to do this course. So you cannot just wake up one day and say, I want to go into franchising. Because what we have realized is that the majority of entrepreneurs who go into franchising not understanding how franchising or how to run a business works, they tend to fail and they tend to blame the franchisor. Some they expect to be trained for the rest of their lives, but the franchisor can only do it maybe for 6 weeks, for 2 months and so on, and then they let you run your business. What we also want to do, and this is what we are doing, we want to have a code that is accredited. There's a talk that this self-regulation doesn't work. So why can't you have a regulatory system in place that will monitor everybody in franchising? That is the talk for the other day, but there's an appetite out there that we should have a system that actually monitors who's doing what in franchising. But then we have the dispute issue. I think you talk about the dispute issue. It's a big chunk, and that costs money. And in most cases, you find that the franchisees are not financially viable to go to the high courts and even to SCA and all that stuff. So we have mediation, but we are of the view that in future we should have either the arbitration system through the code that is accredited in terms of the CPA. I can talk about the CPA. When you mentioned that she was doing consumer law, then I felt, oh, great, I'm not alone. So Section 82 of the CPA provides for industry codes that are self-regulatory in nature. So what we are doing, we are canvassing the department or the DITC to accredit our franchise code so that we can also create an ombud scheme within franchising that will deal with this kind of issues at a fast pace and not so costly. So those are our focus.
Can I just add one point there? Sorry, just it's a very important thing, I think, for the franchising industry, that this new industry code, and the industry code has two main elements. The first is it's a robust dispute. It's a robust mediation dispute resolution system as a step one, ideally for everybody. Franchisors can go there, franchisees can go there. And the second thing is a code of, it doesn't overlap with the CPA, the Consumer Protection Act, but it's a code of, let's call it good behavior for franchisors and also for franchisees. So it fits in very nicely with FASA's plans to, because let's say FASA's, although we've got about, how many franchisees in the country? About 35,000 outlets that are members, but only about 200 of the franchisor members. There are about 800 members in the country. The other 600, many of them they do their own thing. And some of those are the fly-by-nights, the scammers, that bring down the reputation and sometimes hold franchising back. And the plan is to get this franchising industry code accredited for the whole industry, so everyone is then compliant. Not just only the members of FASO who have to ascribe to FASO's code of ethics and good business practices. Okay.
In conclusion,
Sorry. I thought you were finished. Sorry.
In conclusion, we have events that we run throughout the year. We have the breakfast sessions, we have conferences, we have the virtual network sessions, we have golf days, and so forth. So I think we are in a space where we connect business-minded people to come together to talk business and make money. So that's the whole idea of going into business, is to make money. Thank you.
Thank you. I just wanted to quickly ask you, from a FASO perspective, what do you think makes up the X factor when it comes to franchising? So when we talk skills transfer, job creation, investment security, what are your sort of key takeaways? And if someone's sitting in the audience that wants to start, or get involved in a franchise, what are the key benefits and advantages to doing so?
I'll go back to Taekwondo again. It's where you have an excellent entrepreneur who has worked so hard to establish their brand, spent sleepless nights. Then once they perfect their business, then they give it to you at a cost. And I'll say at a minimum cost, because the work that went into it is more than what the franchisees actually pay for. You go and buy into a very viable, profitable system. So secondly, you are exposed to a value-added brand where it exists. It's got its own client base. You don't have to do marketing, going around, failing 3 times, starting up afresh. So you've got a very brand that has excellent goodwill. You also buy into a system, IT, that has been improved time and again. All what you do is to switch on. Then you hit the till and you start to make money. You are exposed to training and support that you wouldn't ordinarily gain if you open your own business. You make mistakes on a daily basis, and you think you are fixing on find that you are breaking more and more. So in franchising, you have somebody who's got a team, because remember, once a brand is of age to be franchisable, already there's a team that is there to support you and to guide you. So the takeaway is that you are buying into a very profitable business, a very proven system, a very supportive IT, and a team behind you to guide you all the way. So your investment is safe. But this is what I've said last week when we were having a breakfast, and one of the main speaker there, I think, is PP Tamayamuyanga, is that when you go into franchising like any other business, because there is a system, there is a support, there is a brand, doesn't necessarily mean that you are going to sleep less. You are going to work as hard as you can in order to make money. One of the issues that I think that we need to talk about, which we haven't touched, is the issue of your investment. Everywhere I go, I'm asked, why do we have to pay this unencumbered cash? Where do we get cash? We don't put cash under our mattresses and sofas and all that stuff. I said, remember, this is the business that somebody has invested their sweat. They wouldn't take a risk of giving it to you for free. Or they wouldn't take a risk of giving to you on credit. Because if you fail to meet your financial obligations, you are going to close down yourself. You'll wake up and thinking, I'm working very hard, but I don't make money out of the business. So unencumbered cash is a mechanism to getting you involved in the business. Because if you don't put in money, you've got nothing to lose.
Skin in the game.
Can I just add something to that? I think the one aspect, I don't know if my mic's still on, if you can hear me. The one aspect I think Mr. Mahato mentioned that we've all touched on indirectly, but not quite directly, is is goodwill, effectively. And what is goodwill is it's an intangible asset or intellectual property or whatever you want to call it that a company has developed where the public knows of its business and it knows of the good work that it's done, and it's gotten a reputation which you then as a franchisee leverage for the purpose of starting your. So if you had to start from scratch, you have to create your own goodwill. But you don't have to, so you're basically starting at 100 instead of starting from 0, which is what the benefit of the franchise from a franchisee perspective is, and why the initial payment that you make as a franchisee, you must look at it in that context. You know, you're not only buying the business system, you're actually buying the fact that this franchisor has spent a lot of time and effort developing this goodwill. And that is the one concept I feel that our courts, in some of the matters that we have been involved in, the one major franchising matter is that they have not been able to properly understand how to deal with goodwill in supporting a franchisor to protect that goodwill. So we made that example of a franchisee taking a business and starting a new business. What you're effectively doing there is you taking that goodwill. You've already established your goodwill in an area that you're practicing in, and you are effectively misappropriating that to set up another business. And that's something that we see quite often. That's the SCA is going to be dealing with a lot of those cases in the upcoming year. And our hope certainly is that there's going to be more clarity in creating a bit of a more balanced view of how to protect that one concept, your goodwill.
Maybe just a question to Adams and other law firms. Does the goodwill of a brand tend to be attached to an individual? Why am I saying this? If I happen to be a franchisee of this business for so many years, and I'm known to be the owner of Fred's Water, for instance, then I move away from Fred's Water, I go to Makgatwa Water. Then the fact that I've owned Fred Water for 10 years, now I'm owning Makgatwa Water. Is there that link that somebody still think that the Makgatwa Water is a brand or is a part of Fred Water? So I think that is one of the issues, that the goodwill tends to follow whether the franchisee, where they go, or the goodwill stops the day they stop being a franchisee.
Sorry, just to come in here, because I have an opinion on this. I think I'm also a litigator, and for those who don't know, I think it also depends on the nature in which the franchisee leaves the franchise, particularly in terms of, Tandor mentioned earlier, the springboarding cases. If you are essentially copying and pasting a business model, whether it's Fred's Water or Fred's Pies or whatever it might be, the fact of the matter is you received that initial, I guess, goodwill, and you understood the business functioning and how it works at a basic level because of the initial franchise that you concluded the agreement with. So for you to then start up a new, or Fred's Water, you're basically using the back of, in my view, and I think it's more relevant to some of a more personal thing, that's some of the stuff we've been dealing with recently, but I do think it's you essentially attaching that, all the knowledge and the goodwill that you had obtained through that franchise agreement with the original franchisor, then copying and pasting that into a workable model to suit yourself. I don't think then that's attaching it to an individual, but I think that's essentially copying and pasting a business model that works, and you know that it works, and that's why you want to branch out individually. I don't know, Tandor?
No, I agree with that. Sorry, the only thing that I forgot to put my phone in silent. Sorry about that. I think that what I look at, for me, what's important is scrutinizing the situation from a facts perspective. I think that the law has you can always look at the law as almost a checklist of things that you must prove for something to happen. But the actual situation is a lot more dynamic than that. And my concern with the courts is that we have not developed a very specific or we have not developed a specific situation to analyzing breaches of restraints and goodwill from a franchising perspective. And what we've then tended to do is look at it from the employment side of things and use those rules to apply it to this side. And I'd always understood when I was a young lawyer growing up, I'm still a young lawyer for the record, Siobhan, that there is a distinction. There's a distinction on how you apply goodwill and restraints in employment, and there's a distinction in franchising. But our courts mix the two. And what ends up happening is that a lot of leeway is given to the franchisee. Even in circumstances like Siobhan described, where you effectively take one business and copy and paste it and make it into company B, which on the face of it shouldn't be the case. It really shouldn't be that way. And I think you might find, for instance, a smaller franchise where there's a hero of that franchise, Mr. Manenza, who's basically taken the charge for the franchise, where the actual franchisor has not done much. So he's coming up with ideas and he's coming up with things, and it's effectively become its own self-standing store. Of course, in that situation, the franchisor can't then try and, if that franchisee wants to go out on his own, he's basically doing that already. But that's not really what you commonly find. What you commonly find is a franchisee goes into a business, he's under that business for 4 or 5 years. There's ongoing training, new business, new changes in the market happen, technological changes happen, there's support from the franchisor, and then one day he decides that, you know what, instead of having a McDonald's, I'm going to call it Manenza Burger, and I'm just going to change the hoops upside down and not make whatever those McDonald's signs are called, and the golden arches. There we go. And from my experience, we don't have clear understanding from our courts yet on how do you protect both parties in that situation.
Kind of just it goes back to what is goodwill.
Yes.
Yeah.
It's an intangible asset.
Yeah.
Value to a business.
Yeah.
What is goodwill?
Yeah.
That's a key question.
Yes. So hence I'm saying, does that goodwill follow me? Because I'm known as.
Let me try and answer.
Yeah. Yeah. Yeah.
Nishan, do you want to come join our panel? Do you want to take my seat? Someone give him a mic.
Should we just give it a name?
Here we go, Nishan.
So I'm going to try and answer your question with reference to what is goodwill. And from the understanding of an IP attorney, goodwill constitutes of various things. But from an IP attorney perspective, it's reputation that's attached to a business. And we talk reputation, what are we referring to? Trademarks, copyright, all of those aspects that you've built over time. And because of it, people associate that name with your business, for example. So we're talking about Fred's Water.
Yeah.
You are a franchisee of Fred's Water. You decide, you know what, this actually is working out quite well. Let me go and start off Freddy's Water.
Yeah.
That's my new business name, Freddy's Water now. It's no longer Fred's Water. So the question is, can you do that? My answer to you is no. Because the name of your new business is too close to your franchisor's name. The other aspects are probably tougher. So if you start a completely different business with a name that is not similar to Fred's Water, that's where it becomes tricky, right? So you start, I don't know, Tommy's Water. Can you do that? And I think that's where our contracts come into play. That's why I'm looking at you, Eugene. That's where the restraints come into play.
No, absolutely, and I'm just going to carry on. I think
Look,
the issue is very often at the end of a term or when the franchise or franchisees decide to leave, they often keep the whole business system that it was given to them, the whole full business concept, and they change the sign outside and one or two things, and they've kept the whole thing. And Tando's point is now there's springboarding, there's unlawful competition, they've stolen all the goodwill. They've used that location has developed its clientele as a result of the goodwill that has arisen as a result of the use of that business system and IP. Then the sign goes off the door and they carry on business. Now the courts are not helping. That's my view.
Because it's difficult to identify the right that you're protecting. That's the issue. You're not using the name.
That's, I think that's the point of where we to bring it to
Yes.
to a what we're effectively talking about. Like when I mentioned the fact of the employment context and in the franchising context, what you're effectively asking is the question: what is reasonable? Because the enforcement of a restraint, a court looks at, is it reasonable to enforce a restraint? You can imagine that the effect of the restraint is far-reaching on the person that is the restrainee, if you want to call it that. They have to give up their business in the employment context. They can't work for a particular point. And in the franchising context, it might be even worse because you've got a store that you've established. You can't trade from that store for a year. There's employees that might be affected by that. And depending on how many stores that you have. So I'm not for a second trying to downplay the serious the serious consequences that can happen to a franchisee. And it's those serious consequences that have made it difficult, I think, for courts to apply restraints properly in the franchising context. Because what ends up happening, it becomes an equities debate. It becomes a debate as to who's going to suffer the bigger consequences.
The small guy, always
the small guy. But the interesting, but why I say it's our courts have regularly enforced restraints in the employment context. They've regularly understood the idea that you have a very important employee in your organization. That employee then goes to your competitors. Is a major part of your business that might be taken with that employee. Now, in the franchising context, it's even worse. You have a franchisee who's not only threatening to go to a competitor, he's in fact becoming your competitor. From the very things that you have trained and instilled in that competitor, from training, intellectual property. In my mind, it's a little bit worse than in the employee context. And our courts, for me, get stuck on one concept on goodwill. And why they get stuck on that is that it's easy to kind of prove you have a trademark that's registered. Some of intellectual property rights are a lot easier to prove. It's very difficult in the context of enforcing restraint to show one fundamental point is that is your goodwill and the rights that you have unique? And what often happens with a franchise is that the business itself is a very simple business. We're using water example. I think that's because of one of our clients is we're having a major case for that. It's very difficult to show why is your business of producing water unique compared to another business. And that's what the courts usually often rely on in showing whether enforcing restraint is reasonable or not. Is it reasonable for me to prevent company B from using companies A's intellectual property or rights if the rights that company A have are not unique, and that's often known as protectable interests.
Doesn't the contract, isn't the franchisee acknowledging the rights?
So,
But the court's not enforcing the post-termination rights.
so you can acknowledge the right, but remember the test is reasonableness. So in determining reasonableness, the courts look at, is there a protectable interest that this company has that is deserving of protection? And establishing a protectable interest, you have to show that your rights are unique, which is quite often not the case in a franchise because all of them are very small, very simple businesses. Water, you're making a burger, or at McDonald's, what is the difference between the two? So that is what I'm hoping that the court clarifies a lot more, because really what the right is goodwill. It's the reputation. I've established this reputation. I'm deserving of that of it being protected. That's what we are hoping, at least, that will be established by the courts. Yes.
Can I sort of add on to that and ask a question? In terms of the litigation, in terms of the litigation and the court's stance, does it help your case from a litigation point of view to have a franchisor who's actively managing his brand, where he's updating the ops manual, where he's conducting training, when he's going and conducting inspections to say, I'm here, this is my brand, this is a reputation that goes with my business, I've been present all along, these are my meetings, these are my whatever. Surely that is part of the management, and does that then help your case at the end of the post-termination?
No, it definitely does. I'll use our case as an example of some some interesting features on it. So I think our franchisor in our case is very active. There's regular meetings, or in fact, it's probably the meetings that kind of led to some of the disputes, ironically enough, with some of the things that were said. But I think that is always going to help in relation to how you manage your franchisees, how active you are in your training. And like I said, mentioned earlier on, there is also a concept of just good faith in dealing with each other that assists all of this. But I think in our context, what ended up happening was the franchisees were dissatisfied. And our franchise agreements had restraints and also had post-termination provisions. So what a post-termination provision often is you are, as a franchisor, must be able to take over that business. You have a franchisee that has now become an errant franchisee. I must be able to get control of that business. And despite the efforts that our franchisor put in developing this goodwill, when the debate came about regarding protectable interests and the uncertainty regarding maybe goodwill, not only did the courts maybe were a little bit reluctant to enforce the restraints, but they then also became reluctant to enforce the post-termination provisions. So as a contract lawyer, for me, those are very plain terms. I agree that once my franchise is over, I give you back the business. It's got nothing to do with the restraint. But because of how all of these equities then intermingled with each other, the courts then became reluctant to even enforce the post-termination provisions, which is, for me, was a completely unacceptable outcome. And the difficulty we also had in that case is that we had a network that were pulling out as a franchise. I think a third of it, if I'm not mistaken. There was a world we could have had court cases all over South Africa, but we chose 3 jurisdictions. And the outcome ended up being that all 3 courts saw the facts the same, but interpreted the law differently. And how do you then now give certainty to a situation like that? So ultimately, I think we all agree that we need to go to the FCA and sort all of this out. But it really, the judges see these questions very differently from one another, and that's unfortunately the situation we're in now.
Maybe I think with the challenges that we are facing in courts, the ombud scheme will help to deal with those kind of issues, because you need people with expertise in a certain area to handle those. Because if you just go to anyone who hasn't been exposed to franchising, irrespective whether you are a judge or not, you get a judge who's being specializing in criminal work. Now you put a franchise issue in front of the judge. And his role is just to interpret the law and the contract as they see it. So I think the ombud scheme will be capacitated by experts in franchising who will deal with this kind of issues. And I'm praying and hoping that it becomes a success before I go on pension.
I think the one challenge there, though, is that ombudsman decisions or rulings are not binding. So I don't think that would have bearing when matters do get to the High Court. But I do hear what you're saying. I think for the interest of time, are there any other questions from the floor? I think there's nothing in our virtual chats. Does anyone else have any other questions? Nishan, my fellow MC.
Mm-hmm.
You sure?
Tell us more about the Pick and Pay story. So what they asked for security.
So they had obviously a normal franchising agreement, and they secured their rights of through a notarial mortgage bond.
Okay, so it's an alternative to like a fee, in addition to a fee.
No. So it's you have an amount of money that you pay in terms of your fee. So then you have to it's basically security for you to pay or comply with your obligations.
There's also a trading relationship.
Yeah.
But it's an excellent model.
It's
now they can diversify from being a retailer to a real estate franchise.
Yeah.
Because
So-
they've now got properties all over the
So
country.
because it's look, their structure works well because it's fixed place. A lot of the fights, the ones that I mentioned were I think there were 10 stores in the East Rand. So if you've ever driven across the East Rand, you see these big, large Pick and Pays, which is basically the ecosystem of the area. And so the material mortgage bond, what happens is that you have to put up movable assets. So in this context, it could be the their furniture, fittings, and so forth. And then you put it up as security, and then when you are at the point where the person has defaulted, you have to go to court, what is known as perfecting your security. So you can't merely just go into a person's house and take it just because you've signed a notarial mortgage bond. You have to get the consent of the court first. But why it's a useful tool in the right franchise is that, firstly, you can go urgently. And because our courts, there's a lot of case law that say that enforcement of a notarial mortgage bond is inherently urgent. But secondly, the idea of having a notarial mortgage bond is to prevent the debtor from unlawfully misappropriating the assets. Because remember, if you give them notice, there's a chance where they might maybe abscond with the assets, and then your security is useless at that point. So not only can you go urgently, potentially on an ex parte basis. So you then effectively have the order, and then you kind of you serve it on the debtor with the sheriff, who takes an inventory, and like with any ex parte order, there's a rule nisi that to make the order final. But it's not going to necessarily work for all franchises. Franchises are rich in assets, goods, those type of things, or you can vet the franchisees in a different way. A lot of the financial banks, for instance, what they will do is they say you can't sign up with us unless you've got assets that we can be subject to a notarial mortgage bond. So, but you can also achieve some of the effects, not quite the same, through the contract itself, where you just say, look, there's a contractual right that I can attach the assets on default. So there's various ways of going about it.
Yeah, maybe just before we go for lunch, because I haven't a tea while we've been wired. The issue of the ombud scheme, why is important. The issue are recommendations. And those recommendations, if a party is unhappy, the recommendation will be referred to the tribunal. So the decision of the tribunal is final and is binding. It's got the court order powers. So that alleviates the whole process of going to court. So that's the shorter way, and why we are of the view that it's important for the sector.
No more questions from you. No, I'm telling you, no more questions. I'm joking. People are hungry. But thank you so much to our panelists for joining today. There's, I think, a lot more to be said. So join us next year for this Franchising Unplugged 2.0. Your MC will be yours truly, Nishan Singh. You got a little bit of a taste today. But thank you so much to everyone for coming and being here. You're a really great audience, and we really appreciate it, especially to our panelists. Thank you, Fred, and thank you to our partners for making the time and for really enlightening us and providing us with some of your key insights and input. So without further ado, we'll be going for lunch. Thank you so much to everyone.
Thank you.